about 9, and
just didn't want to stay.
And I laid down. I was like, want to go?
Not particularly right now.
You're driving.
Yeah.
She's like, I feel fine. And we left. We came back.
Do you go via Amboy or do you take the 15 all the way up?
We did the 15. Yeah, she doesn't like that drive at all.
Oh, no?
No, she hates it.
I hate taking the 15, especially once you get towards like Victorville area and it's like way high up.
Mm-hmm.
Because I've done that. I only take the 15 if it rains, and then it gets all foggy there. Nobody can drive. I'm like, I'm gonna go off the edge of this road or something.
So,
did you guys go to the Kiss concert, or is that?
No, they were there, and we did not go. But I saw the Kiss Volkswagen. Volkswagen Bug made out like Gene Simmons.
All the fans
and,
That doesn't surprise me.
had a tongue sticking out. Or no, what was great is we ended up at a small little drinking establishment on Saturday night that happens to give out free shots every time the Golden Knights score a goal.
No.
They scored 6 goals on Saturday night. Nice. And we're just sitting there, literally she handed us a shot and they just scored again. She's like,
So you know where the Lynx is?
yeah.
So if you go, it's like off the strip, but right behind it, there's like this hole in the wall Italian restaurant, and they give you free wine for dinner.
The pizzas.
Oh, is that, I don't know the name of it, but my friend brought me there, and they just bring you free wine all night long.
It's got all the stuff hanging
on all the walls, and it's got like dim corridors. The entire,
yeah. In fact, it's called Batista's Hole in the Wall.
Oh, is it?
Yeah, and they give you white or red table wine as much as you can drink. Oh yeah.
I can't argue with
And then
that.
they have some. Well, they did when I went there. They have some little Italian guy in his 90s that would go around. He had like a harmonica, not harmonica, an accordion, and he serenades your table. And I'm like,
Much more like that.
I didn't like that.
Yeah, he's kind of cool.
Yeah.
But I got a story about him. He's been there forever. I've been going to that restaurant since I was a kid.
Yeah.
It's been around that long. And, we went there, first time I went there with Karina, he came by and he's like, oh, Lovebirds, you got a song? It's like, oh, you got something for us? And he played some Elvis. I'm trying to think, I don't even know what Elvis song he played, but he played some Love Me Tender or something. And so it kind of became our song when we're there.
Mm-hmm.
So whenever he comes around, I always ask him to play it. And he was playing at another table, and he was coming to us the last time we were there. And I always try to be generous with him because he's a rickety guy.
Yeah.
His back's all over it. It's real.
He's at least like 90, like at least 92-ish.
Right.
So I mean, I
playing recording tips.
Yeah.
Here.
Well, no, he owns the restaurant.
Oh, does he?
yeah.
Yeah, he owns the restaurant.
That's actually really cool.
Yeah.
But I feel for him, and so I as soon as he comes walking up, I give him a tin, and he sticks it in his accordion. So, where are you folks from? Like, California. And I know it because I've seen this stick too many times. He's like, California, he's got a song for wherever you say you're from. He's got a song for you, and he plays that. And I'm like, hey, well, I was kind of hoping to get a little request. And he's like, okay. And what do you want to hear? I told him, I want this Elvis song. And he's like, okay. And he taps. And I'm like, I just gave you. And he turned and walked away. Like, I don't know if he forgot that I had given him money or like, did I give it to him too soon?
Yeah.
Or the timing was off. And I'm like, you took my money and then you didn't even play my song.
Interesting.
And they're just bits. He doesn't play the whole song. He plays like 15, 30 seconds of the song.
Well, the whole song would be like, it would get old. Like,
Yes.
like 4 minutes, play the song for you.
Especially because he goes to each table in your area, and so you're listening to him for a good like
Yeah.
15 minutes by the time he's done.
I'm surprised he doesn't just want to like sit down and like play.
Yeah.
He's that old, you know?
Yeah, he's old. He doesn't look good. He doesn't look like he's in the best of health. So, all right, guys. Personal liability in the corporate context. Okay. So, pre-incorporation transaction. Oh, just so you know, the materials in this chapter, it should be covered in 2 class periods. I don't know if corporations is a year-long class or.
It should be a
So-
2
So
semester
corporations
class.
is usually a semester class, and then business organizations that don't involve corporations is another semester.
Yeah, I'm telling you, when
Like
I was
agency
studying,
partners,
they
you
had-
call it.
they broke it up into 2 different
Right.
subjects. But so we're going to cover 2 classes in 1 class. So pre-incorporation transactions by promoters, right? A promoter, right, is a person who basically is doing that. He's promoting the business, the corporation, before the corporation even exists. So this promoter goes out there, pushes the business, may even sign contracts with third parties. And the question then becomes, who's liable, right? He signed his contract. He then incorporates, and right, who's liable in this situation? When we're talking about, they give you this sample with Goodman and DDS, but I don't want us to get too concerned about that. If it's really going to be based on intent, right? If you intend to bind the corporation, and that's what the party's intent is, and maybe the contract is even made out to a corporation to be formed. Clearly, the intent of the parties at that point is to bind the corporation. It's not to bind the promoter. If you sign it as a promoter, then clearly at that point, it's a contract, somebody's got to be bound, and you will be bound.
I think that's
Okay, unless something happens. Okay, with regards to how you get out from under the liability as a promoter, the corporation can act on the contract, right? They can accept the benefits of the contract that you've entered into. They can expressly enter into a novation of that contract, and or you've got to show that on the face it was the intent that you weren't to be bound. Otherwise, you are. Okay, and the distinction that they tried to make was where was how the signatures worked on the different contracts, right?
How come after the corporation is formed, the corporation doesn't stand in place of the promoter?
Well, you're going to have to show either intent, that was the intent. They're going to have to enter into a novation, or you're going to have to show that they accepted the benefit of that bargain somehow, some way. The corporation has. And if they have, then they're on the hook for it, right? They then become. One of the things that some corporations do is they will include that in their articles of incorporation, a statement to the effect that once incorporated, all contracts entered into on his behalf, specifically by the promoter, who usually is part of the corporation. It doesn't have to be, right? They don't have to be a part of the corporation. Somebody can hire you to go promote the corporation. But if you ultimately are the owner, you're a shareholder, or whatnot, you can put that into your articles of incorporation that upon incorporation, these any contracts entered into will be assumed by the corporation.
But that only indemnifies them, right? I mean,
Right.
the person they contracted with can still go after the promoter.
Yes.
It's just the promoter can
Correct.
then in turn go after the corporation unless there's an innovation, right?
Right.
It just seems dumb.
See, it seems like either either you're acting on behalf of the corporation or you're not.
Well, but you gotta keep in mind, it's all a timing issue.
Yeah, right now, there
I'm
isn't a
acting on
corporation.
behalf of a corporation that doesn't exist,
Right.
right?
Right.
So what if I enter into this contract and then never incorporate?
Right. Well, then you
So
remain personally
somebody's
liable.
liable,
Yeah.
right? Or what if I enter into a contract and I don't tell you my intent is to incorporate? You think you're contracting with me. I then later incorporate and
You remain personally liable. The
Right.
person has
You
to know
see-
that they're agreeing with the corporation,
correct.
even though there is no corporation.
Right.
Okay.
And that's why you tell them, look, here is the plan. This is going to be incorporated, and this is who you're going to be doing business with. And if all that transparency is done on the front end, and you can demonstrate that that's what the intent was, then everybody's fine. The problem is when you don't share that, well, somebody's got to pay for it. Somebody's got to be liable, and they're going to hold the promoter personally liable if those things don't take place. So, what are the consequences of defective incorporation? Okay, let's just go through, just know these names. Okay, I can tell you as I read through this chapter, I was brought back to my bar study. This chapter basically was everything I could in bar study, right? We talked about promoters and pre-incorporation liability and what happens when you have a defective incorporation. So know these labels. A de jure corporation is, Victor?
The Juror Corporation?
A de jure corporation is?
I'm blanking on that.
It's a corporation that was formed.
Properly formed.
No, is improperly formed.
Improperly
They tried to properly form it, but due to some mistake, it was not actually properly formed. But there has to be a good faith effort on behalf of the corporation to incorporate legally. And it has to be a non-substantive error, right?
Right. And a de facto corporation?
What's the
Basically the
corporation?
same.
It's the same.
Okay, hold on.
Yeah,
No, I got that. No, a de jure corporation is a corporation that is properly formed.
Right. Well, substantially formed,
Substantially,
substantially properly formed. Right.
A de facto corporation is when you've taken the same steps, but you have some error in it. Okay? And for all intents and purposes, a de facto corporation with regards to liability is a corporation for all matters except in dispute with the state regarding incorporation, right? You're not de facto with the state because they only recognize the jure corporations, okay? And the last one is estoppel, which basically means whether you're a corporation or not, if you said you were a corporation and you acted like a corporation and they thought you were a corporation, and if somebody comes after you as a corporation, you are estopped from denying or claiming that you were. So it's typically estoppel is a defense. In this case, it's kind of it's reversed.
You don't want.
I thought it was the other way around.
Yeah,
That
because
the third party who's saying that I thought they were a corporation can't then say, I'm going to sue you personally.
Well, they can't either.
I
But,
thought that was
the parties who are acting like a corporation
Why would they want that?
cannot
Yeah.
say they're not a corporation.
Okay, sure.
Yeah.
Well, and I would guess that
I
you
thought it was
could do it,
third party.
I think you could probably do it either way,
Okay.
right?
Yeah.
So
It seems like it's in the benefit of the corporation, though. I mean, the benefit of the individual say, well, you thought I was a corporation.
Yeah, exactly.
So it's like the defense of the guy who's acting as a corporation, who's not a corporation, saying, well, you said I was a corporation, you thought I was a corporation, so now you can't pierce me saying I'm not a corporation. I thought so.
Yeah, man, because I don't want them to say I'm a corporation. That way it'll go after me.
I'm pretty sure.
Because it says the courts have held that a third party who has dealt with an enterprise on the basis that it is a corporation is stopped from denying the enterprise's corporate status, as are the corporation and its shareholders.
Oh, so, okay, yeah,
So
so
it
it
goes
goes
both
both
ways.
ways. It goes both ways.
So, like I was saying, it's one of those principles that goes both ways.
So basically, a de jure corporation and a de facto corporation, I mean, aren't they basically the same? Because the de jure corporation says it's a corporation that is organized in compliance with the requirements of a relevant statute. But it goes on to say that perfect compliance with the statutory requirements are not required. Instead, substantial compliance will suffice. And then it says, therefore, an enterprise that fails to meet all the requirements for incorporation may nevertheless be a de jure corporation if the non-compliance is insubstantial. Isn't that exactly what a de facto corporation is? It's,
Well, a de facto corporation is, you have substantial non-compliance, right? You've tried, but you got something lacking in a serious way. Where a de jure is more, like you were saying earlier, it's a technical violation, it's a minor violation, as opposed to de facto where you're missing something statutorily.
but it's a shitty definition, because the definition in the book says a de facto corporation is said to exist when the steps taken to incorporate the enterprise were insufficient to result in a de jure corporation. So does that just mean that they had to try, but they didn't try hard enough to become de jure, so therefore they're only de facto?
Well, I remember, and I'm going back, I remember examples, for example, a de jure corporation is, I've done everything, right? I filed my articles of incorporation, I've listed some bylaws, I've identified some officers, and maybe I forgot to sign the form that I submitted to the state.
So it's,
Where-
you've done everything right, you just did a simple mistake somewhere.
Where a de facto is, let's say, I've done everything right, I've given it to my lawyer to handle, and I filled out all the forms, here you go, and he doesn't do anything with it. He never even sends it into the state.
So then you.
But I think I'm a corporation, I'm acting like I'm a corporation,
But you're not.
but I'm not, because it's never even been submitted to the state.
Or I could see, like, what about if somebody, like, what I thought when I read this was that somebody just turned in the articles and did
Yeah.
nothing else. They didn't do, they just turned in the articles, but they didn't do any bylaws, they didn't keep any, like not even keeping minutes, they don't have a book.
Right.
Like, they're just walking around
And I would think that would
with
apply.
nothing, with
I would think that
nothing
would apply.
statutorily required, other than they submitted one sheet of paper to the state, and the state thinks that they're incorporated.
I think that would classify as a de facto as well,
Okay.
right? You're not even close at that point, as opposed to insignificant or insubstantial.
But yeah, I guess the example they use is the certificate of incorporation not officially being filed.
Yeah, that's.
That's one.
So, Fletcher v. ATEX.
Okay, so ATEX makes keyboards that hurt some people's fingers. basically. And plaintiff claims that Kodak is liable on a number of theories, including that ATEX was Kodak's alter ego and mere instrumentality. The plaintiff claims that Kodak dominated and controlled ATEX for a number of reasons. The district court granted Kodak's motion for summary judgment, finding that Kodak and ATEX observed all corporate formalities and maintained separate corporate existences, holding that ATEX participation in Kodak's cash management system and Kodak's control over ATEX's major expenditures and asset sales were insufficient to raise the issue of material fact regarding Kodak's liability under the alter ego theory. The rule is Delaware law permits a court to pierce the corporate veil of a company where there is fraud or where there is fact or where there is in fact a mere instrumentality or alter ego of the owner. So fraud or the mere instrumentality alter ego theories. You don't want to be one of the two. Here they're going after the alter ego, and the plaintiff must show that the parent and the subsidiary, one, operated as a single economic entity, dingle for some reason, and two, that's 10. That's an overall element of injustice or unfairness is present. That's the bring it into equity. Like in California, whenever I've seen these, they always end. There's like 12 or 15, I forget, like statutory, like they're actually written out in California.
Right.
And the last two are like justice will be furthered if you ignore the corporate veil, and the last one is justice will be impeded if you honor the corporate veil. And those are the two things that like bring it into equity. Okay, so then it goes through a bunch of factors for the first element, right? The operated as a single entity. They said whether it was adequately capitalized, whether the corporation was solvent, whether dividends were paid, whether corporate records were kept, whether officers and directors functioned properly. 6, whether the dominant shareholder siphoned corporate funds, and 7, whether in general the corporate simply functioned as a facade for the dominant shareholder. In the end, I believe that they held that summary judgment is affirmed that they did not mess with the corporate veil. This was okay, basically.
Right. And this doesn't really. There's not a lot of background on this, but why do you think Fletcher wants to go after Eastman Kodak instead of ATEX?
I would assume because they have more money.
Right.
I mean, Keyboard Maker versus Kodak was a big company for a long time.
Right. Right. And
Kodak.
And Kodak comes in and files the summary judgment basically on this issue, right? Saying, look, you haven't even laid out in your pleadings that we're an alter ego, right? So is that the end of Fletcher's case?
No, because they still have a case against ATEX.
Exactly.
Right.
Right. Now the problem is, and this doesn't tell you, is ATEX able to cover any liability, right? They don't go into that. But it kind of goes to the heart of the benefits of incorporating, right? And most people incorporate because they want limited liability, right? And it's not just limited personal liability, right? In this case, Fletcher went after another corporation who happened to be the only shareholder in ATEX, right? So corporations want limited liability, and that's why they have smaller subsidiary corporations that handle other matters, right? Going to equity, does it sound fair to you? Well,
to not pierce the corporate
just
veil?
in this case, I mean, they went through 5 factors, and
Right. I've never seen this. I don't know. I mean, to me, it seems like they're always going after the person, right?
Not
Like
the parent company.
locally around here, we don't like have too many like huge companies that people sue. So it's usually somebody has like a company that's like under invested and there's no money in there. So you want to go get this millionaire behind it.
Yeah.
That's.
Well, what I was kind of getting at is that I read this, I'm reading this for the first time like you guys, right? And I'm reading it, I'm like, sounds like the plaintiff's got a pretty good case, right? It sure sounded like Kodak was running this company.
Sure.
And even if we look to the single economic entity, is ATEX a single economic entity? Well, the court says yes, but it looked like the facts suggested maybe not. Okay, but here that the court set out that way and said, this is what we're going to find, and you'll see as we go through the cases that the courts get more and more liberal in their interpretation of this single economic entity concept, right? And they start allowing for piercings as we go through, where clearly in this one seems like, Kodak was pretty involved and you were not able to pierce.
And that seems weird to me because this is a 1995 case, right? Well, the other ones are 66, 61, and then with 2000. But it's like, it seems like it just rolls all over the place.
Well, and what you'll see is each state has their own, right? Each state has their own rules. And I don't remember what was.
They're applying Delaware law here.
Or that in Delaware.
Maybe that's the reason.
Yeah. That's why people go to Delaware, right? It's harder to pierce the veil there. So let's take a look at Walkowski v. Carlton. Again, I thought this was interesting, and just how the hell this racket was set up, right? Who wants to talk about Mr. Carlton's taxi cab setup?
We'll figure out the next one.
Okay. So basically, this guy, he owned a taxi cab corporation or a garage, but that corporation was broken down into 10 different corporations, which this one corporation was a part of. And each of those corporations only had the minimum automobile insurance that was required, which was $10,000. So what the plaintiff in this case wanted to do was go after the guy who owns all 10 corporations. That way he could become made whole. And he argued that the corporations were only split into 10 different corporations as the sole purpose of limiting his liability and being able to get the least amount of insurance policies that he could get for these different corporations. And basically, they said that there was no fraud here, which I thought was kind of weird. It says that basically, he's organized a corporation in a weird way that doesn't really make sense, but it also makes sense in the way that he's limiting his own liability. And if you are organizing in a way that is within the law, it isn't fraud, even if you're doing it to limit your liability as much as you can. They said there has to be like an active fraud in order for you to bring a fraud claim. And here, he's still acting within the law, so they're stuck to their $10,000.
Even though sketchy.
Yeah, it's sketchy.
You own, how many cars you own? 20. 20, I got 20 cabs. And I only got to have 2 in each corporation. So I only got 10 corporations. Right, wait a second, we're talking equity here, right? We're talking injustice. You've got somebody who was run over here, and they're like, sorry, no can do, right? They did not allow to pierce because letter of the law, was met. Now this case had a dissent, right? And the dissent in this case took issues with that, right? And they really went down an argument where about the injustice of this outcome, right? Clearly, these corporations are undercapitalized based on the potential liability that they face based on the business that they're in. Right? If you only got $10,000 worth of insurance and you're a taxi cab, what's going to happen? You're going to hit somebody, you're going to hit another car, right? You're going to get in an accident, right? That's your potential liability for this type of business, and you're undercapitalized, and so you shouldn't be allowed to break off in the smallest chunks possible to make one little corporation when in reality you're big. Now, if we look at the corporate structure, Carlton was the sole shareholder of all of them, right? Did he operate all of them? Did he run the day-to-day business of all of them?
No, just own them all.
Yeah, he was on them all, right? He wasn't involved necessarily in the running of them all. And what happens if you follow the law and you've done everything you're supposed to do, and the law then comes in and allows the corporate veil to be pierced? Right? You're gonna
System falls apart.
exactly, right? You're going to hurt businesses. You're going to hurt entrepreneurship, right? The whole point, what we talked about last week, kind of the whole idea about starting a corporation is to limit your personal liability and enable you to take a risk that otherwise you wouldn't be able to take.
Because no one's gonna want to rent by any taxi cab.
Right, and the reality is, I'm not sure if it was in this section or later in the chapter, but they talk about the reality is most businesses fail, right? You start business, you take a risk, you put your neck and your assets out there, you try to protect your family as best you can by incorporating and limiting that personal exposure, and then you go belly up anyway, right?
Mm-hmm.
So if you allow them if you follow the law and you allow them to pierce, you're going to have a huge chilling effect on future entrepreneurship that Judge Keating just doesn't seem to take into account. But it seems unjust if you're the victim of the tort, right? And you're seeking damages. It's like, well,
then it's up to the legislature to raise the
Right,
minimum.
raise the liability
Right.
requirement. He's adequately capitalized for under the law.
Yeah.
You know, it may not be fair, but
right.
but it's the plaintiff's job to pull it into equity. Right. You know what I'm saying? So it stays in law unless you can pull it into equity, and he has the burden. You know, so
Right.
so prove he's not following the law and is disregarding the corporate entity, and he can't here.
I mean, either way, just sue the corporation and sue them above policy and make them sell off all their assets. And
But 10,000's their policy. Their
you can still sue someone for above policy. If you don't settle for below policy, you'll only get the insurance policy from the insurance carrier, but you can go after the corporation for the rest.
fair enough. Fair enough.
Granted, he only has 2 cars and probably doesn't have much of an office staff.
Right.
But still.
You got 2 cars also.
Yeah, you go down the 2 cars.
Those
they
cars
can-
are bright yellow, so you know, get a good resale on them.
I'm sure in New York, or is this New York?
It is.
Yeah, I'm sure in New York City, you can get rid of a taxi cab pretty easily.
So, and there's a note at the end of this, right? Following the decision in Wolkowski, the plaintiff amended his complaint, and the appellate division held that the amended complaint sufficiently alleges a cause of action against appellant that he and the other individual defendants were conducting the business of the taxi cab fleet in their individual capacities. Okay, the decision was affirmed. Nothing that the amendment, noting that the amended complaint now meets the plea required set forth in our prior opinion and states a valid cause of action. Neither opinion stated the particulars in which the amended complaint differ from the original. So basically, this guy is able to, somehow something was lacking, right? So fast forward to part 2 of Olkowski, he files an amended complaint, and they do allow for the piercing.
So I guess the thing that I read in this case was that because they brought it under fraud, and I know like with fraud actions, you have to plead with sufficiency to show the fraud. I guess now that I'm remembering it, the court basically said that he didn't do the pleading enough. Like he didn't allege enough fraud with enough particularity to be able to bring a cause of action for fraud, right?
Right. And he didn't allege originally that Carlton was operating in an individual capacity, right? He kind of just made a broad stroke analysis that he's the only shareholder in all of these corporations, right? But there's that component that you talked about making using corporate assets as an individual.
Right, and they could have gotten that here.
Right.
Because nobody keeps their minutes, right? Especially this cab company is not keeping their minutes.
Right.
Let's be honest. Like,
Right.
there are 2 cabs in a company. There's no way they're keeping their minutes right.
Right.
You know, there's no way that they're not sharing gas. There's no way they're not sharing, like stuff like, not sharing gas, but like, maybe they drive each other's cars once in a while or whatever. Like cover for each other. I mean, you can bleed these corporations together very easily with a well-written complaint.
Right.
That's what I think.
But the problem is you don't know any of that until discovery starts.
It's called, you alleged on,
Information and
belief. Yeah. Yeah. It's true though, I mean.
Yeah, I know. But I thought with fraud you can't do it that way. Like you can't do fraud based off of information and belief. Don't they actually have
No, fraud, you have to,
you?
yeah. You have to allege the specifics of the fraudulent conduct. But for purposes of person to be the veil, person to veil. You can on information, but because you may not know, you have suspicions. We have a case right now where we've alleged an alter ego theory, and we are able to show through a forensic accounting expert that this corporation has been paid this amount of money, and this amount of money has been paid out to him. Right?
He's just siphoning.
Yeah, it's okay. So all of your expenses are to yourself.
Right.
Most corporations have other expenses too, not just distributions to their lone shareholder. So we don't know if that's going to be enough, but we're in the discovery process now, so we'll see what he admits to. Minton v. Cadme. Now we're in California.
California. So this is a company, the Seminole Hot Springs Corporation. They rent out pools, and I'm not sure what the business plan is. But anyway, they have a pool that they're renting from an owner, and the person died in the pool, or girl died in there, and the parents sued for wrongful death, and they got $10,000 as a judgment against the Seminole, but they never paid it. So now with they're using that just the facts that they won against Seminole, and that this Cavani is a director on one of those on Seminole. They're using that to say, well, since he's a director and we already won, this guy should pay us personally for what the corporation owes us. And they went through some analysis. It wasn't enough just because he happened to sit on his board. was not enough evidence because he was also not in charge of litigation. He wasn't a party to it. So you can't just use just the fact that you won and that this guy's on the board. That's not sufficient evidence to show, hey, let's get this guy personally. So we didn't present any other evidence besides that.
Right, and it's they also argued for undercapitalization, right? That
We were underfunded.
So what does that mean, like,
I guess there's not enough money in the corporation.
actually? Like, there's not enough money in their bank accounts?
Right, to pay out potential liabilities.
potential liability.
Is that
So that way, if something goes wrong in your contracts, you need to be able to keep the business afloat. Like, that's kind of like,
There's no insurance, like, they're just saying they don't have enough, like, cannot enough insurance be part of
what
undercapitalization?
they're saying is that is a factor to show that this corporation is just a shell, just a protection of you.
Okay.
Does that make sense? Because if you're walking around with a corporation that doesn't have the assets to pay off liabilities like this, then it's a factor.
Okay.
To show that
Well, no,
all you're doing is protecting yourself.
I was just wondering, because on the next page it says in California, inadequate capitalization can alone be a basis for holding a parent corporation liable. So that's why I was kind of like, I don't know what that means.
Is there a guideline to how much money you're supposed to have available for
Well,
this?
if you saw like the last case, right? By statute, it said you have to have
So much
X
liability
amount
insurance.
in insurance.
Okay.
It was a minimal, but they had the minimal. They complied, right? And Minton, there was no statute on the books that said this is how much liability insurance you have to have if you're running a pool, right? And you're letting kids go in there and swim. It's probably not too hard to imagine today. There's statutory guidelines that will say, here's how much liability insurance you need to have for this type of activity. Okay.
So that would be towards your capitalization, just the insurance, is that count as capital?
It's part of it, but part of it is kind of like Will was saying, it's your liabilities. Look, if you've got contracts out there that value $100,000, and my account's got 1,000 in it, and that's where it sits, right? And every time you get money coming in, you're paying it out to you, and you're keeping the corporation underfunded. It's like, well, wait a second. We're allowing you to incorporate to limit your personal liability.
But you're siphoning.
That's because the corporation is going to assume the liability. And if you're like, well, it's my corporation, you can't sue me. I'm not liable personally. You can sue the corporation. Oh, the corporation doesn't have anything, right? There's nothing there.
So it's not necessarily that the business is doing bad.
No.
It's just that you are intentionally making it so the corporation has no funds in it.
Right.
Because you
Really,
don't want
either
to.
way, though, it's the fact that like there's no way you can even get a just result out of this corporation. You know what I mean? So like they want the you want the person behind you.
Yeah.
You can try.
You can try.
You can sue. And then what's going to happen?
They're either going to say yes or no.
Yes or no. And if you say no, well, that guy skated, right? He's got all the profits of the corporation and none of the liability.
This is getting in the way of
I'm trying to learn, so I can tell my mom, you need to do different things for your corporation.
So I guess it's where you get taxes involved, right? Because as a corporation now, do you want to have a lot of capital on hand? Because then you get taxed on that at the end of the year, right?
No, I mean, you don't necessarily want to have a lot on hand per se, but you got to have sufficient. And maybe it's insurance is a
suing.
right? If you don't have a lot of in and out of your business, then maybe the liability is all you need,
Yeah, because I'm
right? But you've got to keep in mind, like there was a one of these cases coming up. They had like $10 million out in liabilities, and they kept $500,000 in capitalization. Well, if you breach that contract, you're not going to be able to cover that liability. Now maybe you've got other assets, right? You've got these real expensive yellow cabs, right? Will those count? Right? So when we're talking about undercapitalization, it's not just, liquid funds that you have access to. It can be the assets of the corporation.
Yeah, I was gonna say, because don't some use property as tax shelters, like corporation will go out and buy some property and be like, well, that's like corporate expense, we're gonna pay taxes on that. But
Right.
then they can just liquefy that later in case of loss or sell it later.
Right. So let's take a quick look real quick at just some of these little cases here on 306 and 307. Right, Arnold v. Brown, evidence of inadequate capitalization is at best merely a factor to consider. This is the California case and deciding whether or not to pierce the corporate veil. Right. It says it's an important factor, but it's just a factor.
Not part of the next case.
Exactly. Right, and LaTown Fidelity Bank says,
Under California law, inadequate capitalization of the subsidiary may alone be a basis for holding the parent corporation liable for
Right.
the act of the subsidiary.
right, and this was the one I was talking about, right? Their initial capitalization was $500,000, but the investors, had damages in the millions of dollars, and they said, "No, that's gonna be enough." Right, and then we got truck weld, right? There may be situations in which a corporation is so thinly capitalized that it manifests a fraudulent intent, right? We do not find such to be true in this case, but right, it can be, right? Your undercapitalization can be evidence of your intent to defraud the public, third parties.
If something happens.
If something were to happen, right? And then we've got Ratajkowski, right? And Ratajkowski, they had an $11 million insurance policy, and the court said that wasn't sufficient. And why not?
By doing with more than $11 million worth of stuff.
Well, what was the kicker in there?
Well, the insurance carrier became insolvent.
Yeah, they had declared bankruptcy, right? So if your insurer is not good, then your insurance is not good either.
Well, this case basically says that undercapitalization is undercapitalization regardless of insurance. So even if you have proper insurance coverage, you're still kind of screwed because they may go under.
Well, because they may be two means of showing that you're responsible. You're fiscally responsible by having insurance, but it's really not capital that you can expend for liabilities if your liability comes out of something that's not insured, right? Yeah, if you have liability insurance for your taxi drivers, and you then breach a contract, well, your insurance isn't going to cover your breach of contract necessarily for your auto insurance.
Yeah.
And then we've got.
I haven't seen anything about how does debt work? Like if you're in debt and your corporation is dying, it's not necessarily fraud. If you're underfunded, do you still go after the boss or the CEO director?
Well, if the boss has money,
Yeah.
right? look, the reality is when you want to sue, you go after the big money, right? So, you know, like I just read an article that this kid, this Catholic kid with the red hat.
Yeah, we're talking about that.
Oh, okay.
Yeah.
Right, he just sued the Washington Post
Yeah.
for $250 million. Well, right after they hired their lawyer, like this whole list came out of all these people they sent notices to that, hey, you got notice, we're coming for you, right? Because of things that you said that have harmed my client. Well, notice their first suit isn't after an individual, right? Their first suit is after a corporation for big money, right? And I just found it interesting that they sued for $250, and that's what Bezos paid when he bought it. He paid $250. So it's no different than, you know, poor guy gets in an auto accident, you go after the insurance because, you know, if he works for somebody, then you go after who he was employed, whether he was on a frolicking detour or not, because that's where the money's at. Right, so you go after where the big money is. Something to just kind of keep in mind is this is no different than kind of what we talked about last week. If you have a situation where the dispute arises across jurisdictions, and they're able to establish proper jurisdiction and venue in a place outside of where you're headquartered and whatnot, then you know, the rules of determining the law for the case apply. And so you may incorporate it in California and think, well, I want to live by California, you know, piercing rules, and somehow you're sued in Delaware. Well, you may not get California piercing rules. You may find yourself being sued and being held to a different standard. So they do vary from state to state, and you know, you just got to be aware that the law of the case is going to be determined by that analysis, right? Who's got the contacts, sufficient contacts, and who's got the interest in the outcome, and what is their interest at the state level, and, you know, who's a citizen of what.
So are the factors for piercing the corporate veil basically the same in California as they are for Delaware? They're taught in the book.
Yeah, they are more. I actually
More factors.
Yeah, there are more factors. It's
There's 17
Sounds about right.
under Morrison, Knudsen versus Hancock. Commingling of funds, treatment by an individual of the assets of the corporation as his own, failure to obtain authority to issue stock. An individual stating that he or she will be liable for the death of the corporation, failure to follow corporate technicalities. When two corporations are claimed to be alter egos, both corporations having identical owners, directors, and officers, same office or business location, employment of the same employees and or attorney, failure to adequately capitalize. Jesus Christ. Am I supposed to memorize all these for the bar? Jeez.
no, I was gonna.
You can just point out every way that they're like
Not acting correctly.
Yeah.
Right. And just have an understanding. Like if you get into an essay type situation, then you know, then you throw in as many as you can, right?
Or request me to remember them.
True.
17 of them.
True.
On top of everything else for
The
corporations.
thing is, first year we would have been like, all right, let's take a flashcard.
I know. Now I'm just like,
It's like, God dang it.
I'm just looking here. So the general rule from 2009.
It's in the folder.
Courts are reluctant to bail pierce unless there is affirmative evidence of fraud or wrongdoing or gross failure to follow formalities. Wolkowski v. Carlton. Okay?
well, that's the case we just
That's the
read.
case we just did. And we pulled that out of that, right? That two-prong rule. The general test is a corporate entity may be disregarded when a plaintiff can show such unity of interest and ownership and such control that separate personalities no longer exist, and under these circumstances, adherence to the fiction of a separate entity would sanction fraud or promote injustice. And the courts look to the totality of the circumstance. So, and that's going to be, I think California is more like specific, where this general rule right here is going to enable you to identify those facts that fall under that.
But yeah, and I think some of the things that he mentioned are like alone sufficient. Like one of the things you mentioned is like somebody agreed to be personally liable.
Yeah, well, no,
That's
those
That's one
are
of
the
the-
factors.
That was one of the factors you mentioned, right?
Mhm.
I think that's alone probably enough. Like if you say I'm personally liable,
Yeah, I'm good. You can sue me.
yeah. Well, no, sometimes we see going all the time where people require, like, I'm only going to enter this contract, this risk with you if you personally guarantee it on the back end. And like, happens all the time. This is scary, but
Yeah.
I'm not going to give you this money unless you guarantee it on the back end personally.
Right.
Yeah, and that's what we used to do with the bank all the time.
Really?
Yeah.
Okay.
If you wanted a corporate credit card, somebody in that corporation was signing to be personally liable.
Oh, okay. There you go. There you go.
And no one in the corporation ever wanted to sign to be personally
Of
liable.
course.
Okay. We got Eisenberg's corporate groups, notes on empirical analysis, and variations. And we jump to, all right, I'll just point this out to you guys. I'll just read it to you. You can see what it's telling me. It pulled from the book. Sometimes it pulls stuff out and I'm like, is that what that said? But, yeah. Eisenberg makes the point that subsidiaries rather than divisions within a single company are preferred because it is a risk management strategy. And Cardozo reminded us that companies may well be separate entities, but at some point it is perverse to show the parts as separate. That perversion would appear to exist in the eyes of the beholder, as the empirical evidence later reviewed and the frequent attempts to pierce the veil each support the view that this is an area of ad hoc determinations guided by fairly fuzzy standards, right? And well, you're kind of cutting it, right? This sword has two edges to it. Right? Either you're gonna get the benefit of limited liability, which may inherently seem unfair, or you're gonna hold, somebody personally liable, and that necessarily is gonna have a chilling effect for others down the road before they think, do I want to incorporate, or do I even want to open a business.
So it's really hard for a small corporation to follow every guideline for corporations. I mean, I know the book says you don't have to because it'll look at how you do things, but still, I mean, for like a mom and pop corporation to follow everything, it's near impossible.
Right.
Exactly. It's true. It's basically impossible.
Yeah, it is.
Well, it's one of those things where, especially if you're the lone shareholder, right? We'll have a meeting. How do I feel? All right, this is how I feel. Okay.
But yeah, that's what I used to tell my mom and dad. Like, you guys have to have meetings. You have to have, and they're like,
You at least need to.
it's us. What are we gonna meet about?
Yeah. Well, the thing is, though, that you can literally have 3 people stand around and be like, "All right, we all had a meeting. We're doing what I say. Everybody sign here."
Yeah.
You know, like that's the direction is.
Mom, my mom's always like, I'm a majority shareholder. What I want goes. I'm like, all right, whatever you say.
Now jumping to section 4. Right, the note in this section reviews how veil piercing issues can arise in the context of determining whether statutory directives or policies are being circumvented by a party creating a controlled company to engage in action that the parent company could not engage under the statute. So it's not necessarily a liability-based determination at this point. It's more, wait a second, you're enjoined from doing something. You can't now have one of your lower subsidiary corporations do what you can't, right? So we've got Brotherhood of the Locomotive Engineers versus.
Somebody do it, or you know?
You can help me out. How about like
Okay.
lean on co-counsel a little bit? Okay, so here we have 2 corporations that are both railway switchers. They are like owned by the same guys. There's 2 brothers named Fink and a guy named Kelso and Mellon. And so they're all the directors in all these companies. And one company gets in trouble with union tactics, and so they decide to do something with the other corporation. They switch his customers, and out there.
So basically, what happened is they were going to strike, and there's specific procedures that are supposed to be followed when they strike to stop the strike from ever happening. And the one corporation was hiring people to go into the other corporation to be replacements for the workers that are about to strike, so they could get rid of the workers that are about to strike, so that way they wouldn't have to make better their employment practices.
Right. Yeah, so they enjoined both companies for these tactics, I think, essentially. Seems a little bit different than piercing the veil, though, right?
Right. Well, it's this is a statutory construction, right? So you have the Railway Labor Act that's in place, and it's got a component of that is how to deal with strikes, right? When you can't strike, and what the parties can and can't do during the course of their striking. They're saying Springfield, the parent company, violated the statute by saying, hey, subsidiary, I can't do this because of the Railway Labor Act, but you can, because you're not bound by it, right? These aren't your workers. And they said, no. So it's not really piercing the corporate veil in the traditional sense where you're getting at assets for liability purposes, right? This is a situation where you're making a determination that an entity is trying to subvert or go around the law by using a subsidiary. And the court says you can't do that.
So the big rule that I got out of this one was that if it's a federal case, federal courts aren't bound by the alter ego fraud requirements that state courts put on people. It's more that a corporate entity may be disregarded in the interest of public convenience, fairness, and equity. So basically, a federal court can go straight to the shareholders or the directors and say, you're liable because it's fair.
Right.
Which just seems a lot easier, and you should just do
All the time.
corporations.
All the
federal
time.
court.
Right. All the time. Now, given these facts, okay, do you think this court would find Springfield liable
Yes.
for ARB's debts?
Yes.
Right? If ARB was liable for somebody and they wanted to go after.
We would need more facts, different kinds of facts.
No, it still said that. I mean, it's the exact same board. They're owned by the same people. They work in conjunction with each other. I mean,
But are they sharing employees? Are they sharing assets? Because the biggest thing is the sharing of
Are
assets.
they a
not in a federal case.
What's
and
that?
Not in a federal case.
right?
Assets and liabilities, right? That's what you, like, what you can't do is put all your liabilities in one company and your assets in another. There's a case on that, that some people try to do that, they own two companies, they put all their assets in one, all their liabilities in another, and you'll get Pearson in second trying to do that.
That just seems like fraud, like
Well, yeah,
straight up.
it's a simple, if you can prove that, you get Pierce. Yeah, I don't know.
So there was a dissent in this case, and they said, "What are you talking about?" Right, like dissents always do. That's the essence of every dissent. Like, what are you talking about?
Yeah, he wants to add, or they want to add more to look at than just equity. You're like, there are three standards that should be followed, not just when we feel like it.
So, well, let's talk about the notes here at the end, right? Does a statute or contract that applies to a corporation also apply by implication to the corporation shareholder? Right, for example, if Corporation A agrees with X not to compete with X, may A's sole shareholder compete with X?
Say again, sorry.
It's note 1 on 314. I mean, it'd be shady business practices, but the corporation can't bind a shareholder. It's another private party. I mean, unless the shareholder, by becoming a shareholder, agrees to be bound by stuff like that, I don't think the corporation can bind someone else.
But here, A is alone the sole shareholder.
So the guy, not the corporation he has, but the director, pretty much.
He's in.
Oh,
He's
yeah,
the owner, director,
Like, can he compete as a private person, not as a
Right.
corporation?
not as a corporation.
Not if he's a sole shareholder. I mean, then you are the corporation.
Right.
I mean, if he's one shareholder of hundreds, then no.
I was gonna say, what if it's like, he's just not using that name of his company, he's just on as a private person. What if his company's what has the goodwill to whatever he can compete with? Yeah. He still has all his knowledge and experience, I guess.
Well, it would appear to me kind of like it's definitely shady, but is it illegal, right? Are you precluded from doing that?
I say no. It's just much more shady if you're the sole shareholder than if you're one of many.
Because the argument for the guy would be like, well, I'm not competing with you as, Amazon.com, I'm competing with you as like,
Jeff Bezos.
as Jeff, as Amazon.
Yeah.
So, yeah.
Yeah.
I don't know. Yeah, I mean, I frown upon it,
Okay.
It'd be frowned upon, but I don't think it'd be illegal.
No, I don't think it would, not in itself, without more facts.
And this is gonna be one of those situations where you're gonna go from court to court, and you're gonna get different rulings. Right, there's not gonna be a consistent rule that comes out of the different courts.
But using the Amazon example and that fact pattern, I mean, if Amazon agrees not to do something, Jeff Bezos also owns Washington Post as well, right? I
Right, they're
mean,
completely different.
so
Yeah.
you can't have the shareholder, you can't have the contracted care of Amazon get imposed now to the shareholder, which then gets imposed to the corporation that shareholder is also a shareholder of. I mean,
Right, so if like the Washington
Where does
Post
it cut
and
off?
somebody else decide to share information and they decide to not share information with other people or whatever, I don't think that like hurts Amazon at all. Amazon can go
Yeah.
wherever the heck it wants. I mean, it's not involved. So I think it depends on the
Well,
involvement.
let's flip it, right? Let's say you got the Washington Post, right? It has a non-compete with Washington Examiner, right?
Mhm.
Not gonna compete with you. And then Amazon goes out and starts buying up newspapers, right?
it's
And-
shady, but it's not
and
illegal.
then running those newspapers.
Yeah.
And,
I would think that the two I mean, to me, it's a factor showing that the two corporations are working together and they're one entity. They're working as a single entity. And if we get enough factors to show that they are working as a single entity, and a court could hold that they're a single entity, you're looking at a bad time.
Yeah.
What I'm
You know what I
thinking is, well, you're not using the goodwill of the entity you've agreed not to use. So in that case, Amazon is not using that publishing company that had to compete.
Yeah, but then you're doing shady shit like the railroad company did, and
Yeah, but that's absent a statute because the railroad company had a specific
Yeah.
statute for how to handle it. But if there's no
Well, here you
statute
got a
in place,
here you got a contract.
there's a contract. Oh yeah, we have a contract. Well,
I'm not gonna compete with you.
as the corporation, so I won't compete with you as Amazon.com. That goodwill is not going to be put on the table.
Pete's Taco Cart won't compete with, Victor's Taco Cart.
Yeah.
Right, but I'm gonna go as, myself
Yeah.
and start a taco cart.
Yeah, there's
You
not
know.
Victor Taco Cart. I'm not going to use the goodwill of that name I've built up over time. I'm going to go start fresh. I'll compete with you as a brand new company over here.
it's shady, and you're getting sued. But I don't think you're gonna lose. You're probably gonna settle.
How about, does a statute or contract, that applies to an individual also apply by implication to a corporation that the individual owns? Right, so now we're going
Not at all.
down and up, right? For example, if a statute prohibits non-citizens from owning ships that ply the U.S. coastal trade, does the statute also prohibit a corporation from owning ships if all the corporation's stock are held by non-citizens?
And if it's a U.S. corporation, I mean, the corporation is an entity in and of itself,
Right.
separate from its owner.
I don't know. What are the rules about incorporating?
Yeah, I had some questions about that. I mean, along that lines, because my mom wants to incorporate the dental office so that I can inherit it. But I keep telling her, well, I'm not a dentist, so I don't think I'd be able to run it or own it. But she thinks that if it's a corporation, I just own the corporation and not necessarily the practice or something like that. Just trying to find a way around it, but I don't think that's possible, is it?
It might be.
I think there's professional responsibility on the medical board that you can look up.
Yeah.
But to me, it sounds like a professional responsibility question regarding a physician and, what kind of directorship. Like, for example, in law, you can't have a non-lawyer and a lawyer partner up to own a firm.
Exactly. So,
Maybe in medicine it's different and you can partner up with a doctor.
but I think, I don't know, because also, you can't own a dental practice without a license.
Oh, you can't?
You can't.
Okay, then that's
No
probably your
license.
answer.
So
Yeah.
that's what I'm thinking, even if we incorporate, it becomes like a corporation.
The best thing to do is then is probably just try to sell it, sell goodwill. That's sad, but.
No, I mean, exactly, that's what I was saying.
Just become a dentist.
We'll go another 4
Go to
years.
Loma Linda. Just become a dentist.
So, these are questions of interpretation, right? And the courts must bear in mind that on the one hand, the law normally treats a corporation and its shareholders as distinct. But on the other hand, the legislature or the contracting parties may not intend to treat a corporation and its shareholder as distinct.
I don't think it's up to the courts to decide. I think if the legislatures wanted it to apply to non-U.S. citizen-owned corporations, they have to put it in there. They can't. It's not up to the judges to be like, oh, well, this also applies to them.
Was a corporation an American citizen?
Yes, because a corporation is an entity in and of itself and separate from its shareholders.
And it can own the boats.
So I would say that it can own the boat.
Yeah.
But what's the rule as far as like not having any assets in America to go after? Like
Well, your corporation would.
The corporation should be funded if you're going to pierce and get all kinds of.
I mean, if your corporation is an American corporate entity, and at least as long as your funds are in America,
It's funded in America. It has enough liquidity in America. It's capitalized in America.
and I mean, you can still sue them and go after their assets in a foreign country. I mean,
It's going to be hard, but
Nobody can do it.
yeah, you just sue them in federal court, right, to get their assets?
Yeah.
And then you have to get the assets from the other country, but
Good luck.
it's still plausible.
So you just have to,
It is. It is.
you got to open up a Costa Rican bank.
Yeah.
But just note the Supreme Court concluded that parent shareholders would be deemed shareholders of the bank for the purposes of a statute on the ground that to hold otherwise would permit that purpose to be undercut. And there's a quote. It has often been held that the interposition of a corporation will not be allowed to defeat a legislative policy, whether that was the aim or only the result of the arrangement. So it would seem to imply that you can't, right? If you are under contract or there is a statute, right, to go to our coastal fishing analysis, not a statute that prohibits non-citizens from doing it, and you're a corporation and your only shareholder is a non-citizen, then you would be precluded as well. That's my
Statute should say.
Would you have to bring on board of one director that's an American citizen at least, or is there like a minimum amount of Americans that has to be?
It's a good question. I don't know the answer to that. I don't know if to incorporate here, if you have to have.
You have to have a place for service of process in California. But that could be a lawyer's office.
But do you have to be?
Let's say you have an agent for process.
Yeah.
No, but I'm thinking like in this fact pattern, say like a Chinese company is trying to own the boats, and they want to do it, but they could just use a shill like this guy's a director, he's an American citizen.
Yeah, they got their straw man.
Yeah.
Oh, so you're saying there's more fraud out there?
No, I'm saying I want that job, but I have to sit around and get
I'll be your token American.
So what type of law do you practice? I'm a director for sale. Bring your corporation to me, I'll run it.
You need American, I'm your
I just sit on a
American.
bunch of boards and collect paychecks. That'd be great. Yeah.
Not a horrible idea, but to like start a business with, foreign nationals to have a business here. I mean, it's just investment.
Corporate director for hire.
It's just investment.
Measly $60,000 a year per corporation.
Plus expense
That's like a windfall for a director. For it.
for a corporation. Yes, that'd be great.
Yeah, just pay some random guy $60,000 for the year to be your director in America. That's cheaper than most directors will get away from.
Yeah, piece of cake. I don't know how we did it, but we got through chapter 7 in less than 2 classes.
Got through it in less than 2 hours.
It was less than an hour and a half, yeah.
Yeah.
We started 2 minutes early, now we're 2 minutes
I don't know
after.
how we did, but what I want to hear is that you guys took advantage of our short class last time, and you got your community property
Dominated.
stuff written.
I did. Although I couldn't go to class because all the roads were shut down. But I did. Well, you missed all the rain, didn't you?
Yeah.
Yeah.
No,
Although you had issues coming back into Palm Springs, but you still missed all the rain.
it was interesting because it was raining. It started raining as we left, and so we got rain on the way up. Once we got to, Victorville and whatnot, up over the mountain, it stopped. It stopped raining. There was no rain, and we just kind of cruised all the way in.
And you came into that, you're like, what the hell
I've
happened?
seen all the videos and people are posting and tweeting.
Yeah.
Oh my God, it's raining! Yeah, it's like, the road to the tram is out. Highway 111's out. Adams Street, you can't cross it. Like, what the hell's going on?
It took me 2.5 hours to go to Bermuda Dunes and back.
Wow.
Yeah.
Our
Yeah.
That's right.
Because all the washes were shut down. I had to go 111. Everybody had to go 111 all the way down.
Warner.
Well, but there's only so many bridges. There's
But I
no
couldn't get
bridges
back
in
across.
Palm Springs or Cathedral City.
No.
So you go. Well, there's in where Gerald Ford and Vistachino meet. You know what I'm saying? Like that's a bridge. And then you have to go away to Bob Hope, and that's it. Those are the two closest to the Palm
Yeah.
Springs. It's wild. There's no other bridges. I mean,
Yeah, so
on that side of the
unfortunately-
valley.
No, instead we're spending money to count the homeless.
Well, somebody wants to know how many we have.
Well, no, that'll solve the whole problem. Build a bridge that just live under it.
Yeah, exactly. So keep my roads open and give them a home.
So, two birds in one stone. Sorry.
Makes them easier to count. You know where they are.
Exactly. They're not all in Duluth Park or wherever they all hang out. Ruth Hardy Park.
Oh, there's a lot there.
Oh, there are. I see them every day when I get lunch at Ralph's.
Yeah, I drive right past that. Probably the best. So I was right there across from there was somebody had put up like almost like a tent out of a
cardboard box.
No, out of a bus stop. They had like a tarp and and I was just like, if a guy wanted to catch the bus, I could have a seat or you're all comfortable.
Nobody's catching the bus at that bus stop. I mean, my God. Nobody's catching the bus at any of those bus stops in Palm Springs.
And do that, but then I'd be like, adverse possession is messed up.
Yeah, this is my bus stop now. I've been here for 20 years. Actually, 10 years in California. 5 years in California?
You have to pay the property tax in California.
Can you pay property tax on bus stop?
Yeah.
I'd like to pay the property tax at the bus stop at Sunrise and Almost Ramon by the Boys and Girls Club that was also just flooded out.
You get your easement.
Yes.
What's sad is it's right there, you never see any kids playing there with the Boys and Girls Club. Right there.
You do have if you go by there like midday, they are out there.
Yeah.
But actually, the other day they were out there by all the cranes, and I'm like, that's a lawsuit waiting to happen right there.
Is that Crane Corporation properly capitalized?
I don't know, but I doubt Boys and Girls Club is.
No, I doubt. I think you're right.
Let's say they're asking for donations to fix the flooding, so.
Well, we fixed it.
They
finally unlocked it.
No more false imprisonment.
No more false imprisonment.
Thanks for that.
I'm sorry for cutting so early. It's all right. We'll get more information.
I feel like I learned enough for it.
We'll have a good review class.
I will